It is a privilege for me to be here with Judge Scheindlin. I am so happy to be asking you questions and not standing up before you.
Answering the question.
Yeah, ask it, right. And so why don't we just start in. Let me just, though, say, I don't know whether everyone knows, everyone in the eDiscovery bubble that you and I travel in knows you as legendary because of your various opinions, the 5 Zuba Lake opinions, the pension committee opinion, and many others. There are some facts that maybe you all don't know, even some who've traveled in these circles. You were a prosecutor, you were a commercial lawyer, you were assistant U.S. attorney for the Eastern District of New York, you were general counsel of the NYC Department of Investigation, you were a special master in the Agent Orange mass tort litigation, and you were appointed to a judgeship in 1994 by President Clinton. You replaced Louis Freeh, and you've served for 21 years and have been senior judge on the court for the last 5 years?
You could have left the last out.
Okay, all right. So with all of that said, you've been on the court for 21 years. Why don't you sort of take us through how you have seen changes in legal practice before you?
Well, thank you, first of all, for inviting me. This is kind of fun. It's a big change from having listened all day to an economist tell me about event studies. That was not exciting. This might be, but that certainly wasn't. In any event, to answer your question, I suppose one of the biggest changes I've seen, and I know it's because I'm in that bubble, but the use of electronically stored information, which we call ESI, is everywhere. There is no case, civil or criminal now, that doesn't involve ESI. And that ESI, can come from all kinds of sources. It's not just email anymore, social media, GPS devices, cell phones. It's ubiquitous, it's everywhere, and everybody has to understand it, everybody has to get a handle on it. So that's one thing that I think has changed. The other thing that's changed in the 21 years I've been there is the tremendous decline in trials, which I think you're all aware of. Nothing goes to trial. And I've thought long and hard as to why we've seen such an enormous decline in trials. And I think one answer is going to surprise you. And that is that the American system of discovery, which I know you all complain about in big business, but it's so robust that there's very little left to try. By the time you finish that kind of discovery, people really know what's going to happen at a trial anyway. So they might as well settle. They do settle. They do it on motion because the discovery is done. They've actually seen the witnesses at deposition and heard them. There's not much left to do. So in a certain sense, I think the American system of robust discovery has actually had a salutary effect, and we shouldn't maybe automatically think there's too much discovery, it's too expensive, it causes delay. I'm not so sure. It eliminates an uncertainty because we know so much about a case. Another thing I would mention is the way we prepare for litigation. This is early in our conversation to bring up technology-assisted review. You all know it as TAR, but it is changing the legal world. There's just no longer going to be reams of young and very unhappy associates sitting in big rooms doing doc review. I can't tell you how many associates have quit the law, left the law, because they hated doc review so much. That may be a thing of the past. The machine does it better. A well-trained computer, if you understand this at all, develops algorithms, figures out what's relevant and what's not, and can sort through millions of documents in much less time with much higher accuracy than any person hands-on can do. So the ability to use technology as a friend and not an enemy is a big change. On the other hand, that means that all of us who are over 60 are very nervous, because do we really understand technology? Are we really competent to deal with technology? We weren't raised with it. But as you know, the ABA rules have changed, and lawyers are now required to be competent about technology. It's right there in the ethics rules. So whether you like it or not, you can no longer say, oh, I don't really understand, ask a young associate. No good. You folks are really responsible to the court whenever there's an issue that might involve technology. Another change I see, of course, is discovery from foreign entities. There's so much cross-border discovery now because there's so many multinationals. I'm sure people in this room represent multinationals all the time. And I don't remember 21 years ago constantly getting questions about whether or not we can obtain information from a foreign entity, which have, by the way, very different privacy laws. That's one thing we're aware of, is the American view of privacy is certainly not what the rest of the world's view of privacy is. So we have a lot of barriers to deal with when we talk about EU countries or Asia or South America. Very different set of rules, and the courts have had to adjust to that, and I'm sure you have too. So there are others we could talk about, but I'm sure we'll get there. Those are the ones that come to mind immediately.
Well, can I ask, you did say the ABA model rules addressed with a comment, competency for lawyers. I know we didn't discuss this, but what about competency for judges? So let's sort of level set here. You know, there is a cadre of lawyers a cadre of judges that go to conferences and understand technology-assisted review, but there are hundreds of judges, thousands really at the state level and federal level. And so I guess I'd sort of some level setting here about judges and what they could do to be educated in these new algorithms and analytics.
Yeah.
And then secondly, talk about the lawyers who appear before you.
Okay. So first of all, judges are getting younger too. Obviously, except for the Supreme Court, judges do age out of the business and they do retire. And in fact, there are age limits and term limits in many states. So they're going to be younger. They're going to get it much more than sort of earlier generation of judges. That said, in the federal system, I think we have a tremendous amount of training for judges in these areas. There's not a year goes by that the federal district judges, the federal magistrate judges are given training in this area. I can tell you that the appellate judges know nothing about it. So you don't ever want to get before an appellate judge because they are living in a different world. Mind you, these issues don't get to the federal appellate courts hardly at all. The Supreme Court, though, has weighed in surprisingly in a trio of cases in the last few years. They stayed away from this, and suddenly in Kwan, Jones, and Riley, they took up pagers, cell phones, and what's the third one? GPS. They took up all three of those devices and talked about privacy and warrants and what you can learn about people. They realize now, because they have cell phones and they have GPS and they understand how much tracking is there, particularly the younger justices. Justice Sotomayor and Justice Alito have both written very interesting concurring opinions saying this is your life. Your life is on a cell phone. So they understand because they are younger. So anyway, the Supreme Court is really getting there and addressing these issues. Now, the state courts, different issue. That's a difficult one. There are just, as you said, there are thousands of state court judges in all kinds of specialized courts. I think the commercial division judges here in New York, like the federal judges, are constantly getting training. Same with Delaware Chancery Court. So business courts, which I think interest you most, those judges get it. But we're seeing more and more ESI in family court cases, divorces. You know, what gives it away more than your Facebook page? So are these judges getting that kind of training? I don't know. It's a resource issue. So they're a little bit behind the curve. But that's my answer on judges.
Now, how about, so outside counsel appearing before you, sort of, are you looking at a curve where you're increasingly confident on the competence of lawyers to address complex technology, or are you finding severe or material weaknesses?
No, let me say that in the federal court in the Southern District of New York, I'm probably spoiled. I mean, that's a real commercial court. And I don't know what goes on in Nebraska and Kansas and everywhere else. But in Manhattan, in the commercial cases where this really arises most, the lawyers are better and better. And we've helped them get there. We have a special pilot project for complex cases where we wrote an ESI protocol. So we've really helped the lawyers to be up to speed. But I would have to say in 90% of the cases that come before me easily, they never heard the word ESI, and nor does it matter. Those routine kind of cases don't seem to involve this problem. But in the 10% of big cases, big, product liability, environmental, class action, securities fraud, that kind of case, they get it. They really see change. They're up to speed.
And I know that you have used special masters. Are you sort of up on special masters, special expertise to help judges in courts, or are you neutral?
No, I'm for it when needed. I mean, special masters don't come for free. So if a case has enough at stake, and we do have, as you know, those kind of cases in the Southern District of New York. If a case has enough money at stake, the lawyers want the help. They're happy to have a special master because no judge is going to have the time to sit with them and really go over the different techniques, the different search terms, whatever the dispute may be about. So sure, I'm for a special master, and actually I would encourage two parties in a commercial case to ask for one. I don't see how it can help but help you.
So you have been at the forefront of rules changes, the 2006 rules changes. You were writing about that before 2006. You've been involved in the discussion with the rules changes coming up at the end of this year. There are thousands of comments that were put in by plaintiffs' bar, by defense bar. It felt like...
By judges.
By judges.
I wrote one.
And there were very strong views on both sides. And so give us your crystal ball thoughts on, first of all, what the rules changes, the major ones are, and what we can all expect as litigators and clients.
Okay, I don't know if this audience is overwhelmingly litigators, and I don't know how many of you know about the changes to the Federal Rules of Civil Procedure that will take place December 1st, 2015. The last big round was 2006. I was a member of the Advisory Committee in Civil Rules and lived through that series of changes. This time I wasn't on the committee, but as a former member, I was invited to a number of their sessions. So you need to know what the new rules are, because they're definitely coming. Everybody's on board. The Supreme Court has agreed, so they're not going to change. They're here. So the first big change is in Rule 26 that describes the scope of discovery. And for the first time, the scope of discovery has changed. It has no more relationship to the subject matter. That's over. It's only relating to the claims or defenses. It used to be an included subject matter. Then in 2006, we changed that to a second tier. You could get subject matter on good cause. Now you can't get it at all. It's claims or defenses only. So it's narrowed. The second big change is that for the first time, the scope is defined by proportionality. I think that is a huge change. That word is now in the 26B scope definition. And it says that it has to be relevant and proportional to the issues in the case, and it gives the judge about 6 factors to figure out whether it's proportional. So when you get a document demand or an interrogatory, and if you're on the defense side, forget the defense side, you're on the side receiving the demand, you can object saying this is not proportional to this case. They are doing this just to drive a settlement. It's not necessary, and then the court's going to have to make a proportionality determination. I don't know how that's going to play out in terms of expense and delay, because are we going to have reflexive proportionality motions now on every discovery request? I certainly hope not, but it is an arrow in your quiver now to object on the grounds that it is not proportional. And you'll see the new rule gives the factors that the court is going to have to consider. The rule does not say who has the burden of proof, however. Interestingly, it doesn't say that the party seeking the discovery has to prove that it's proportional, or the objecting party has to prove it's not proportional. So that's still an open question, and it will develop over time. The other one is they changed the language about leading to the discovery of admissible evidence. It still says that, but it cuts back on the remaining part of that phrase. It eliminates may lead to the discovery of admissible evidence. So it has to be something that's relevant now. It can't lead to the discovery of relevant evidence. Okay, there's another kind of narrowing signal, which is that when you get a protective order, explicitly it says you can ask for cost shifting. And the rule makers have been trying to do cost shifting for years. You know, there's a lot of unhappiness with the American rule. So now for the first time, there's a very explicit provision that says a court can grant a protective order and shift the cost. So I think cost shifting is finally making a breakthrough. So these 3 changes together, or for the claims and defenses, the proportionality, the cutback on relevant evidence, not leading to it, and the protective order idea with cost shifting, all of that is a huge signal that the rule makers are trying to rein in and cut back on discovery, which I suppose is good news for those of you who think that discovery is too broad. Okay, the other big change is on Rule 37E. I do want to cover that. I don't know how many of you are sanctions phobic, but this is the rule on sanctions. The reason to be sanctions phobic, I'm told, is you over-preserve. That you're worried about preservation because you're worried if something is missing, you're going to get hit with a sanction, which is not only costly, but it's embarrassing. You become sort of a target. Once you've been sanctioned, you're sort of more at risk of being sanctioned again. So the new rule changes the sanctions regime entirely. It's divided into two parts, and the first part has no culpable state of mind requirement at all. So you don't have to act negligently, willfully, recklessly, or any of that stuff. But if there's prejudice to the party that suffered the loss of information, then the court can take what's now called curative measures. It's no longer called sanctions, it's curative measures. And the curative measures are not the extreme sanctions. The curative measures are fines and attorney's fees, maybe preclusion, further discovery, things like that. Although there's one thing I'll go back to when I tell you about the second half. The second half of the rule, however, is the heavy sanctions. The adverse inference, default judgment, dismissal. To get that for the first time, in federal court anyway, there's a uniform standard across the country, and it's called intent to deprive. So unless there's proof that the loss was done with the intent to deprive the other party of getting this information, there won't be a heavy sanction. And that is a big change, because in the Second Circuit, mere negligence was enough. Whereas in the Fifth Circuit, you had to show bad faith. But this circuit split is over. It has to be intent to deprive, which I think is a very high standard to show that somebody actually destroyed the documents intending that you don't get them. But if you don't show intent to deprive, you don't get the adverse inference, the default, or the dismissal. Now that said, let me flip back to the first half again. In the curative measures, there is one interesting twist. It's in the advisory committee note, not in the rule. But it says that if something's lost, and you can't prove intent to deprive, you can still put the facts regarding the loss in front of the jury, and then the judge says to the jury, you can draw whatever inference you want from the facts you just heard, which is interesting. It's not quite an adverse inference, but it still lets the jury hear all about how this stuff got lost, and then telling the jury it can infer whatever it wants. I suspect that's very close to an adverse inference, and in the end, the jury will say, oh, this stuff got lost, they should have been more careful, we're going to draw an inference. So there is sort of a back door that was left open, even in the curative measures side of Rule 37. So what the new rule didn't do, and some of us hoped it would, was set forth more guidance on preservation. We know when we heard these 2,000 comments, a lot of businesses begged us to, it wasn't really us anymore, I wasn't on the committee, but it begged the committee to really address preservation head on. But the committee thought it couldn't do that as part of the Rules Enabling Act, because the rules don't kick in until there's a litigation. So they really couldn't tell you what your preservation duties are. But all I can say is you're at much less risk than you were, because of the culpable state of mind for the big sanctions is so high, being intent to deprive. So that's my overview of the rules. There are other little ones along the way, but I didn't want to go through every one of them.
I'm going to ask Judge Scheindlin one or two more questions, but I do want to cue the audience that we really did want to leave a substantial amount of time for your questions. It's not every day you get to interact with Judge Scheindlin or a federal judge. So think about that. Let me ask you, you haven't been here today. I've been here from the beginning. Right. I can tell you that we've gone through a number of interesting reactions to the big law problem, which is that big law faces challenges with respect to in-house counsel and with respect to other organizations with providing consulting and other types of services in the legal area. I have heard the words anxiety, shock, and a number of other states of mind that remind me of the DSM-5 disorder manual on the part of big law. So I guess the question from your side of the bench, what do you see as the sort of change in legal practice? And is it a good thing or not to have all these other players other than the traditional big law firm?
Well, as you said, I'm on the other side of this. I am not in a big law firm, and in some ways, therefore, I'm not qualified to answer that question. But that said, I know that technology and vendors and consultants are becoming part of a law firm, and they're becoming part of in-house counsel's office. I know this. And they're maybe even blurring the lines of what is the practice of law and who is permitted to practice law. When you turn over your doc review to a vendor, who's signing off on 26G? I mean, who's the party that's really responsible? And again, the ABA rules, the ethics rules, which were recently amended, said the lawyer is. The lawyer has to supervise whoever the lawyer hires. So if you hire a vendor or a consultant, can I use the word? Your ass is still in the sling. I mean, you're still the responsible party. There's no doubt about it. You'll be held to account if anything goes wrong. The judge isn't going to say, oh, who is your vendor? I'll punish your vendor. I mean, I really have no power over that, but the lawyer is an officer of the court. So I think the lawyer can't sort of escape responsibility by using these adjuncts, even though I realize these legal adjuncts are playing a bigger and bigger role in firms and in in-house counsel. And so we may have to have a new definition of who can be sort of a member of a firm and share profits with the firm, and what is their responsibility, and what oversight does a court have. It's certainly raising a lot of issues, because I don't think lawyers can be technologists. Sure, some of the young ones really love technology, but you're never going to do it full time. You went to law school to be lawyers, so you're always going to be somewhat dependent, I think, on this new field of experts who truly understand all the technology. And I don't want to make it sound small. I started out with my very first answer saying it's everywhere. It is. I used the word social media, but I didn't mention the cloud. I mean, it's just, electronic data is everywhere. We didn't mention the word Internet of Things. There's just nothing we have that doesn't record what we do. I'm wearing a Fitbit. Everybody knows where I've been. I have no privacy left because I choose to wear this darn thing. But same thing in your cars. If they can subpoena your GPS, I mean, these are things people do in litigation now. And I should have mentioned that earlier too. Backtracking again as to why there are fewer trials. One thing I thought of as to why there are fewer trials is everything's recorded. Nobody speaks anymore. So there was a time when you had a he said, she said. The conversation wasn't recorded, so there was really a credibility determination to make. Somebody had a meeting, two people talked. They said there was a contract. They said there wasn't a contract. Who knew? But nobody talks now. Everybody emails or texts. So actually, it's all written down. Again, you can't have a trial because the proof is incontestable. Once it's written or videoed, it's incontestable. So just for the fun of it, let's talk about body cameras on cops. We won't have assault cases anymore because it's going to get recorded. And it won't be a question of was it self-defense or did he do it first. It's going to be recorded, and we won't have the Rikers Island problem because they're going to have cameras in the halls and cells. So we won't have the prisoner cases. So the world is changing. Once it becomes incontestable, there's not much left to say. So this digital revolution, which I realize 2 or 3 of my answers have focused on, is in every case. It's all written down somewhere.
Well, so there's a little bit self-serving. You and I, when we're in the movie, we're talking about the sort of the advancements in the law with respect to technology-assisted review and analytics. You've been very hard on some parties before you, pension committee case, in not getting their act together as corporations and not issuing a legal hold in a timely manner in a written way. So I guess the question from an information governance perspective, since I spend my life in this area of counseling corporate clients about it, is whether you would, you're comfortable saying to lawyers and law firms and in-house counsel that they really should work on taming the chaos that the big data world represents, doing a better job so that they can queue it up, set it up better for discovery and for litigation when it happens.
Right. Okay, so Rule 37, which I spoke about a moment ago, I forgot to say that the introduction says that the measures or the sanctions only kick in if the material should have been preserved in the anticipation or reasonable anticipation of litigation and the party failed to take reasonable steps to preserve it. So we have a new phrase, reasonable steps, and I think that's what your question is geared to. We are going to have to assess whether you took reasonable steps before we can hold you responsible or not for the loss. So it's certainly to your advantage, as you put it, to be organized in your information governance practices so that you can defend that you took reasonable steps. And I've held the view all along that it's not reasonable to fail to issue a litigation hold when you reasonably anticipate litigation, or worse yet, when it's brought, which was one of the problems in pension committee, that there were no litigation holds. I mean, if you don't preserve the stuff once you're supposed to, I don't think any court will find you acted reasonably. So while I can't say that the law says it's mandatory to have litigation holds, it's not, but it certainly is your defense. It's your defense. It's your way of showing the court that you took reasonable steps, and then things happen. So I think the court is very amenable to the notion that things happen. One topic I don't know if I'm allowed to answer a question I wasn't asked, but I wanted to.
You're the judge.
Yeah, I know. For 21 years, I know I'm the judge. One thing I wanted to talk about is how all this technology has impacted the courts and the courtroom. And it really is interesting. Electronic case filing, we call it ECF. You all know about it. It's changed the world for us. We can access any document at any time at our fingertips, and so can you. You can get any docket entry from any case, and you can cite any judge back to herself, especially if it favors your side, and say, as you ruled in the last 5 rulings, and they're at your fingertips. We can carry all this around on an iPad. I mean, we're also mobile. We can find anything on the docket at any time in any place. Presentations to the court have changed enormously. There's no jury trial now without graphics, PowerPoints at opening, PowerPoints on summation, and PowerPoints, or graphics anyway, throughout the questioning of a witness. The document is on a screen, then a yellow highlight comes up. You don't have to publish it to the jury anymore. It's all there. But the same for the judge in non-jury hearings. Today I had, as I said, this 5-hour hearing in a securities fraud case on whether there was an efficient market. And both sides had PowerPoints and handed them up, put them on the screen. We were all literally on the same page at the same time. So that world of presenting has changed too. Nobody just talks without a visual that makes it so much easier to understand what you're seeing. And to capsulize. There's always these summations with, here are 5 points, and the 5 points are right in front of you. So the world has changed between the filing, the presentation, the access that you have and that we have, and the ability to carry all this around without you. We're doing video conferencing now. We're doing court call, if you've heard of that, so that 50 lawyers can be on the call at once with no trouble. So the courts are really making leaps and bounds with use of technology. Okay.
One last question from me, and then I will go to your question. What can courts do to reduce costs in litigation?
Yeah. Well, I think the best thing we can do, I would like to preach to my other 39 colleagues, but we can decide our motions promptly. I have taken that as a rule that's governed my 21 years, and I think it's really judicial malpractice to sit on a motion for a year. And don't show me your hands as to how many of you have waited a year for a judge to decide a motion to dismiss. That's a terrible thing. That just increases the cost because people keep having to work on the case when it could be over. So an efficient judge can reduce costs, in my opinion, right away by deciding their motions promptly. Secondly, we don't need a motion for everything. So in my courtroom, I say, you can't even make any discovery motion. Just write me a letter. Both sides write me a letter. Come on in. I'll read the letters and I'll rule. And I'll tell. I don't need a brief. And so a fast access to the court, a fast ruling for the court really keeps down costs because, as I said, there's no trials. So basically the time and the money is in motion practice. If we can cut back on motion practice, which you really don't want to hear if you're in the firms because that's how you make money, but I know these motions cost a lot of money for you to make, but in any event, we can reduce costs, I think, by cutting back on motions and deciding issues promptly.
Okay.
Okay.
Questions?
Well, there's one.
One from the gentleman back there. Mr. Horn.
Using the term gentleman usually. Hi,
there
Judge.
you go. Hi.
2 questions. One, technocratic, and the other one sort of philosophical, riffing off of Jason's cost point. The technocratic question is, could you talk about Rule 26F conferences, and do you think they're being used as well as they could be? Are there some techniques, recommendations that you would put forward about how they can be used better, or if you're comfortable with where they are now. The more philosophical question is that I take your point that with the greater discovery that's allowed today, that trials become fewer and far between and everyone has decided everything.
Or redundant.
Or redundant.
Yeah.
But the other point has been made, and I'm going to quote one of your recently retired colleagues, that because ESI is so expensive, because going through the process is expensive, this person has said, does that relegate the courts to a playground for the rich? Does it somehow deny access or add to that? So those are one technical question, one philosophical question.
Okay, the technical question was 26F. And again, as a judge, I don't go to 26F conferences. That's the conference between the parties. So I don't know what they're really doing in there. I know the new rule, the amended rule that's coming out December 1st, has added 2 mandatory topics that you're supposed to cover at the 26th and then put in your report. And that is preservation. So that's a good thing. We didn't write a preservation rule, but at least we mandated that you discuss preservation and report on your decision, which will force the lawyers, I think, to get realistic about talking to each other about the scope of preservation. You can't and shouldn't preserve everything. You gotta decide who are key players, what really needs to be preserved, what time frame, what kinds of information need to be preserved. So that's there. The other one is Rule 502, Federal Rule of Evidence 502, which was a great rule, and then nobody paid any attention to it. And it's essentially, I would call it the anti-waiver rule. And it says if a privileged document is produced, it doesn't even say inadvertently, but is produced, I guess it means on purpose or inadvertently, this will not create a waiver, either for that document or subject matter, in any state or federal proceeding. So the federal rule even protects you in state. And that's a really good thing because you don't have to be so terrified that if one document slips through your privilege review, you've blown the whole thing. So now it's mandated that you discuss 502 and preservation. So look, I think that lawyers, at least in big cases, again, complex cases, business cases, are taking 26F seriously. They are meeting, they're writing detailed reports, they're agreeing. The last panel talked about collaboration, but this is called cooperation. But I think they're working together. In the little cases, I don't think they're bothering, but I don't think it matters. I used to think there was a move on to write rules they were called simplified rules for simple cases on the civil side. I oppose that. But now I changed 180 degrees. I think there should be rules for complex cases, complex rules for complex cases that wouldn't apply to the other 90%. So in any event, I think in the cases where they should do it, they're doing it. In the cases where it doesn't matter, actually, I don't think they are doing it. Now, the philosophical question. I don't buy that. You haven't identified my former colleague, but I don't believe that it's turning the courts into a playground for the rich. In fact, Dawson, the truth is, the only cases that go to trial are for the poor. The only cases I try are false arrests, prison assaults, employment by a pro se, and FLSA, Fair Labor Standards Act, overtime cases. The cases you guys have, they settle. They may settle on the eve of trial after years of discovery, but they don't go to trial. So the courts are open for constitutional type cases, but I don't think we're a playground solely for the rich. I do realize the cost of eDiscovery is expensive, but I think technology is going to bring it down, not up. And that's what I would urge you to appreciate, that is actually the cost should be decreasing if you're doing it efficiently. And I heard on the last panel, there was one in-house general counsel, the companies aren't going to pay for you to do it inefficiently any longer. When they know that there's a good way to do it, I don't see why they should pay for an outdated, old-fashioned, associate-heavy, sorry about your profits, but I don't see why they should pay to do it inefficiently.
Is there a day coming that you would rule that it's not reasonable for a firm or their client to use technology-assisted review in a large, complex matter?
You're saying it's
not reasonable because they, if they didn't use that, if they used old-fashioned methods
that it was not
manual review.
It was not reasonable not to use it.
Yeah, not to use it. That's what I mean.
I would never say what I'm going to rule. Just like the Supreme Court justices, I'm not going to comment on a case that I may have in front of me.
It's just between you and me and the camera here.
And 200 people, right, and on camera. So I can't quite answer that. But if they had to defend whether they, let's say, the time it's taking, they want a 3-month extension because there's millions of documents and we haven't had the time, I might say, well, what review are you using? Why haven't you been able to get it done on the schedule that I set? Well, we've got 50 manual reviewers. I would say, are you kidding? So I certainly am aware that there's a faster and I think eventually cheaper way to do it without saying how I would rule if it wasn't utilized.
Question in the back over there.
Hi, I was hoping that you might be able to share some views on companies that are implementing through their email exchange servers or through their technology a very, very short retention schedule. Obviously they're going to try to do it in accordance with any applicable rules or regulations, but you see some companies having a 30-day cycle where things just kind of get auto-deleted, or instant messaging type things where after a very short period of time, the data is deleted and then wiped. Any views on that, or how you think that's interpreted in the court and how you think that might evolve going forward?
Well, I know you're getting a kick out of being able to ask questions of a federal judge, but I think it'd be fun to punt initially and ask Jason what he thinks, and then I promise to fill in the gaps. If it gets through the infield, it'll go to the outfield.
Well, we all know that the governor of New York has had something to say about short retention periods for email, at least in the public sector. I think depending on the vertical you're in, you've got issues because of the requirements to preserve documents for longer periods than that. But that is a conversation that one could have with one's client depending on where they sit. And it may well be that it works for some, but I would question whether you're putting the client itself is putting itself at more risk with that shorter retention period.
Okay, so to add on to that answer, I would say it all has to do with reasonably anticipates litigation. A lot of the companies that you folks represent are serial litigators. Serial litigants, sorry. You know that suits are coming and you know the issues on which those suits are coming. That's what you do. I mean, those of you who have products, you know there's products liability. Those of you who do environmental stuff, oil and gas, you know there's going to be environmental issues. Knowing that, to not have, and I guess it's called information governance, to not have a plan for what you really ought to exempt from that auto-delete 30-day is a bad idea, to not have a plan. So I think to distinguish between that which really should be retained, because it's virtually inevitable that you're going to want the design documents for a new product or the testing documents for a pharmaceutical. They're just things you cannot delete if the researchers are talking back and forth. I can't give enough examples, but I think you follow my point. To be able to separate that which is trivial or is just daily life and not going to be needed from that which is inevitably going to be needed in the next litigation, that would be information governance to me. Now, in some fields it's regulated. So in the securities business, it's recorded. The conversations are all recorded. There's a retention period. This stuff is held for 5 years. The same thing with medical records. Same thing, education records. So there's a lot of regulations, putting aside common law that I'm talking about. A lot of this retention is, you know better than I do, Jason, but there are laws and regulations and rules as to how long you have to retain and what you have to retain. So it's not as simple as to say, my company deletes everything in 30 days. Nobody can do that now, I think. So
we have reached the end of the time. Let's all thank Judge Scheindlin.